I have a very interesting topic today. It's whether a young person, that is a person under the Youth Criminal Justice Act, who's just over 12 or under 18, because that's the definition of young person, whether that person can be tried as an adult under certain circumstances. And yes, under certain circumstances they can. The benefit of the Youth Criminal Justice Act is, for people under 18, we generally, in the vast majority, if not 95% of cases, if not higher, we treat them as a young person. So for offenses, they face far less times in custody or jail, and we tend to avoid custody as much as possible. And the maximum periods of custody are not long either for the normal youth criminal justice case for a young person. Now, how does this work where the Crown wants to treat them as an adult? Well, I'm giving you an example. I'm giving you an example of a case I did, which I thought was inordinately unfair. I fortunately won the case. I had a client a few years back, just a few years ago, who, I won't tell you the county or the facts or anything like that, but he was charged with sexual assault, which occurred when he was 16, involving a person who was just over 4 years younger than him. So it was just kind of out of the age of consent, just by a smidgen. And the complainant came forward, 15 years later, and the complainant said this person had sex with me, which I agreed to, but it was illegal for a number of years, and then it became legal, by the way. And they were both the same sex at the time. And so the Crown gets a hold of that case, and I thought, well, he'll be tried. It's a pretty not morally terrible case. It's not like a 50-year-old man having sex with a 12-year-old boy, for example. It's like a 16-year-old, 12-year-old. Still wrong, still out of the age of consent, but kind of at the lesser moral end of the spectrum, obviously. So the Crown gets a hold of this case, and I was the trial Crown, and I represented this person who's now an adult. And they say, we're seeking an adult sentence. I go, oh my God, are you serious? And they said, yep. And they're allowed to do that. They're totally allowed to do that. No, any of my colleagues who heard this thought this was just reprehensible on the Crown's part. It's their right, but usually they exercise discretion in these things. So now my clients, instead of facing maybe a very short period of custody or maybe even no custody, given the facts and given it happened years ago and given it's not totally morally reprehensible, although illegal and wrong, I admit that. No, we know that. He's facing like at least a 3-year sentence, if not more, in jail, in an adult jail. And he was literally losing his mind over this because we had a lot to lose. He had a lot to lose. So it totally backfired on the Crown, though, because now I was allowed to have a preliminary inquiry, and I was able to show all the inconsistencies, inherent improbabilities, bad character of this other person who had serious motives to lie. And we fortunately won the trial. But there's an example of where they can seek an adult sentence. So in other words, if you commit a crime as a young person, say even a few years ago, now you're over 18, the Crown, in their absolute discretion, can seek an adult sentence. I think that's a very unfair system, but that's our system. Now, there are also provisions under the Youth Criminal Justice Act which tend to be applied appropriately, not always in my view, but if a youth is charged with murder, for example, and they're close to 18, there's an example, or 17, there's an example where the Crown might apply to try them as an adult. Maybe that's appropriate if they're close to 18 as an example. But I'm just giving an example where it's totally unfair in another situation. Unfortunately, we won that case, but unfortunately it backfired because the only reason we won that case is the preliminary inquiry gave me a chance to kick the legs out from under the complainant to show that they were lying. And ultimately the judge found that they were a complete liar. So we completely exposed the case. If I hadn't had the opportunity to do a preliminary inquiry, I think it would have been a much more close call. I'm not totally convinced we would have won the case because I had all this great evidence to use, there was no question in the judge's mind that the complainant, the victim, lied because they had motives to lie, which came to fruition at the trial and preliminary hearing. So there you have it, a little short primer on how the youth criminal justice system, in certain circumstances, the Crown can apply to treat the person as an adult, and years later can seek an adult sentence when you committed a crime 20 years ago as, say, a 14-year-old, and now have you sentenced as an adult. Is that fair? I'll leave it up to you. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.